It is my pleasure to introduce you to the moderator for this panel, another distinguished alumni recently of the law school, another one who was the editor-in-chief of our International Law Journal here, which does such great work. Keith Petty also went on to work for the Yugoslavia Tribunal, and he has been currently instrumental in the Office of the Military Commissions, and his trial is the Omar Kadar case, which will begin November 10th if it's not delayed. And he's bringing some sanity to that office and probably to this panel as well. So, Keith, the floor is yours.
Thank you very much. Good morning, everyone. It's my privilege to introduce our second panel. The topic we will be discussing is drawing the line, humanitarian intervention, actions to combat terrorism, and aggression. We've already learned a great deal this morning about the origins of the crime of aggression and the shape the draft definition is taking. With this background in mind, we must ask, when does the use of force rise to the level of aggression? This is often referred to as the threshold question. The UN Charter does not prohibit every use of force. Article 2.4 of the Charter prohibits the aggressive use of force. However, if authorized by the Security Council, or if a state exercises its right to self-defense or collective defense under Article 51, then armed force may be lawful. Modern conflicts tend to blur these lines. The current draft definition contains modifiers that are meant to preclude investigation and prosecution of outlying claims of aggression. For example, in order for individual criminal responsibility to attach to state action, the act must be a manifest violation of the UN Charter. How then do we treat humanitarian intervention? Many agree that under a strict construction of the UN Charter, humanitarian intervention is not legal. On the other hand, many also agree that it is morally defensible. Will the use of the qualifier, manifest violation of the UN Charter, distinguish humanitarian intervention from aggression? Should it be distinguished? Will the ICC lose some legitimacy if it does not strictly construe acts that would otherwise be considered aggression without regard to their object and purpose? Actions against terrorism raise even more issues under the threshold question. The prevalent view is that prior to exercising self-defense, a state must be the victim of aggression or an imminent attack. But what if a state is attacked by a non-state armed group? Under the current draft definition, only states may commit aggression. This calls into question any time a state uses force to combat non-state armed groups, in particular, targeting terrorist groups. Similarly, it is fair to ask what the Bush Doctrine is, and not just to our vice presidential candidates. Specifically, the issue is whether preemptive self-defense is a manifest violation of the UN Charter when the Charter itself permits self-defense in some circumstances. The bottom line is this: will a crime of aggression serve to deter adventurous military expeditions, or will it give pause to states wishing to engage in humanitarian pursuits or lawful self-defense? With these issues in mind, it is my privilege to introduce our expert panelists. Professor Shawn Murphy is the Patricia Roberts Harris Research Professor of Law at George Washington University School of Law. He previously served in the Office of the Legal Advisor for the Department of State and as legal counselor to the U.S. Embassy in The Hague. He published an award-winning book on this very topic, Humanitarian Intervention, the United Nations in an Evolving World Order. Next, we have Professor Michael Newton, who is the Professor of the Practice of Law at Vanderbilt University School of Law. He negotiated the elements of crimes for the International Criminal Court and has worked extensively with the Iraqi High Tribunal and the Special Court for Sierra Leone. He recently co-authored the book, Enemy of the State, The Trial and Execution of Saddam Hussein. Next, we have Elise Leclerc-Gagné, who is a PhD candidate in political science at the University of the British of Columbia in Vancouver. She previously served as a research fellow at the Center on Peace Mission Studies at the University of Quebec. Her research focuses on the protection of civilians during armed conflict, specifically the protection of civilians, international humanitarian law, and political and international relations theory. And finally, we have Professor Larry May, who is a professor of philosophy at Washington University in St. Louis and strategic research professor of social justice at the Center for Applied Philosophy and Public Ethics at the Charles Sturt University in Canberra, Australia. His research focuses on issues relating to collective and shared responsibility, issues in international criminal law, professional ethics, and the just war tradition. And quite recently is the award-winning author of the book, Aggression and Crimes Against the Peace. We will begin with Professor Murphy, please.
Thank you very much, Keith, for that generous introduction, and thank you to Michael Scharf and the sponsors of this conference for inviting me to come. It's a real pleasure to be here. The paper that I've written is entitled Criminalizing Humanitarian Intervention, which seemed like a catchy title, so that's why I picked it. And since some of you may not be aware of what humanitarian intervention means in the international law world, we are not talking about $700 billion for Wall Street, which is perhaps one form of humanitarian intervention. We are talking about the use of military force, transnational military force, for the purpose of protecting or stopping a widespread deprivation of human rights in the targeted country. So this is quite different from self-defensive force or other kinds of ways you might imagine using force. And when we talk about this concept, oftentimes you'll see a subset referred to as unilateral humanitarian intervention, and what that normally means is intervention of this kind that's not been authorized by the Security Council. The reason why that subset's important is that it seems generally accepted that if the Security Council authorizes an act that looks like humanitarian intervention, you might think about the U.S. going into Somalia in December of 1992, or the authorization by the Security Council for states to intervene in Haiti to oust the military junta there. Those sorts of interventions are typically regarded as lawful because they've been authorized by the Security Council and there's no problem. The problem that arises is what if states do it on their own initiative. And so that's been referred to as unilateral humanitarian intervention. Obviously, you can have a group of states doing it together, so it's probably not the best name for it, but I'll stick with it for the time being. As a general matter, I think it's right that unilateral humanitarian intervention is regarded as unlawful by most states, by most entities that are specifically asked to address it, by most scholars who look at it. There are some incidents out there that look somewhat like humanitarian intervention, going back to things like Tanzania going into Cambodia, or Tanzania going into Uganda. That would be an interesting intervention, wouldn't it? Wow, those Tanzanian, paratroopers. Or Vietnam going into Cambodia, obviously, or obviously the most recent one that gets a lot of attention is NATO going into Serbia with respect to Kosovo. So you've got some discrete incidents there. The problem has always been that the reaction of the global community to those incidents has often been mixed. Sometimes it's condemned at the General Assembly, sometimes it's not. Often the Security Council is stymied in doing anything because of the permanent member veto. So there's a certain level of unevenness in the practice, and that's made it quite difficult for a norm favoring unilateral humanitarian intervention to crystallize. Now, having said that, there is a fairly trenchant minority position out there, one that I think tends to be grounded more in concepts of natural law or political philosophy, that speaks less to, what exactly does the charter say and what exactly is state practice showing, and more to the idea that when you have human rights in jeopardy in extremis, surely it must be the case that a state can intervene to stop that we can't hold up the value of state sovereignty and stability as paramount in situations where these extremely grave human rights abuses are occurring. And there have been some, in the aftermath of Kosovo, some interesting reports that have come out to that in support of that. You may be aware of the December 2000 report by the International Commission on Intervention in State Sovereignty, which is called the Responsibility to Protect. Also R2P is sometimes what you hear referred to there. And it seemed to suggest a belief that this form of unilateral humanitarian intervention should be permissible. In any event, as I see it, the debate is still unresolved, with heavily orientation towards not allowing this type of intervention unless the Security Council authorizes it. So what I tried to do in my paper is ask the question, will the ICC's assumption of jurisdiction over the crime of aggression, or maybe activation of this jurisdiction, affect the debate in some fashion? And here's what I'm thinking. If we assume that the definition of aggression is silent on the issue of humanitarian intervention, meaning it doesn't expressly include it or expressly exclude it, and I think that's a pretty good assumption based on the proposals that are currently in play. If we also assume that the definition of aggression covers most major instances of transnational uses of force, right? We've already had discussion today about manifest violation of the Charter or some such, threshold level. If we assume that that's what ends up coming out, I do think that sweeps within the scope of it most of the things that we talk about when we talk about humanitarian intervention. We are talking there about states bombing other states or states moving forces into other states. I mean, humanitarian intervention sounds gentle and cozy and all this stuff, but it's a pretty, robust use of force when you look at the types of incidents in the past that have happened. So I do think that in some sense, the crime of aggression before the ICC will potentially encompass acts of humanitarian intervention. And I'm also going to assume, just for purposes of my 15 minutes, which is now rapidly down to 8 minutes, I'm also going to assume that the trigger for ICC application or investigation of such a crime is, at the end of the day, left with the ICC. And that's a bigger assumption that may well prove to be wrong. But let's assume that the Security Council can't block the ICC from acting, and it may be delayed 6 months or something. But in any event, the ICC can, on its own, initiate an investigation of the crime of aggression, either the prosecutor or in conjunction with the pretrial chamber. Assuming all of that, and assuming that an amendment is adopted and is widely adhered to by states, again, that might be a questionable assumption. But let's just say you end up getting 104 or more states signing on to this amendment. It seems to me that ironically, the result of that in the long term may well be to result in the crystallization of a norm favoring humanitarian intervention. That is, the thesis is that the trenchant minority may ultimately win out here in establishing that there is an acceptable norm of transnational uses of force for humanitarian purposes. Why do I say that? It seems to me that if you had one of these incidents of humanitarian intervention of the kind we've seen in the past occur, and you had the prosecutor being expected to scrutinize that intervention and reach a determination as to whether or not to indict the leaders of the country conducting the intervention, I think it's highly unlikely indictments will flow, assuming it is true humanitarian intervention. That is, assuming that it is truly designed to stop a widespread use of violation of human rights, if it's necessary to do that, if it's proportionate in the way it's conducted, all the sorts of criteria that you hear talked about as to what would be an appropriate humanitarian intervention. If all of that is the case, then it seems to me it would be highly unlikely the prosecutor is going to actually issue an indictment. That may be because there's a sense of prosecutorial discretion here, that if it's a just action, even if it looks like it might be a technical violation of the charter, I think the prosecutor would likely lay off of it. It may be politically quite difficult for the prosecutor to indict in a situation where, say an Idi Amin has been ousted from power. And I think that there may well be benefits to the prosecutor from such an intervention going forward, right? If we're assuming that the targeted state is a state that's been engaging in extreme human rights violations, that may well include violations that are within the scope of the ICC's jurisdiction, possibly. And maybe by this intervention, there's a greater likelihood of getting your hands on persons that you've already indicted at the ICC, okay? So if those types of factors are in play, it seems to me it may be quite unlikely for the prosecutor to indict. Now, in the paper, what I do in part is say, what would have happened if at the time of the intervention in Serbia by NATO in protection of Kosovar Albanians, what would have happened if the ICC had jurisdiction at that time over the crime of aggression, and that it was fully in play, that all the right states had ratified the, amendment to the statute and whatnot. I just don't see there's any way that the ICC prosecutor would have indicted leaders of NATO. And why is that? Well, you could try to argue, well, it wasn't a violation of Article 2.4. Well, I don't know how you make that argument easily, right? There are some things you can try to say, but I think it's hard as a just sort of positivist approach to interpreting international law. So maybe the prosecutor would indict, but I think the prosecutor would have been more influenced by the idea that there was some level of justification for this, that Milosevic had been shown to be a rather robustly aggressive individual throughout the 1990s, had inflicted or unleashed or been associated with widespread violations of human rights, that the likelihood of Kosovo enduring those kinds of violations was perfectly plausible. You didn't have the Security Council authorizing the intervention, but in the aftermath, you had the Security Council basically adopting a resolution saying, okay, we are where we are. We're going to, bless this ceasefire agreement. Russia fully cooperating in that. Russia even deploying troops into Kosovo as a part of the UNMIK process. Support coming from different quarters, from the Islamic Conference, for instance, and things of that sort. I think ultimately it would have been extremely difficult for an ICC prosecutor, and that's just leaving aside the practicality. I mean, imagine indicting Bill Clinton, Tony Blair, go on down the thing there. States that are basically, major players, and in the context of the ICC, at least for something like the states that are supporting the ICC and funding the ICC, it takes a lot to expect that the prosecutor is going to proceed to indict. Now, you might say, well, Kosovo is kind of unique, right? 16 NATO countries, and maybe this doesn't apply to other interventions, and maybe that's right. But again, I get back to, if you actually went through each of those prior interventions, is it the case that Tanzania would have been, Nyeri would have been indicted for going into Uganda and ousting Idi Amin? I just have great doubts about that. So, in the last couple minutes, what I'll say is that if that is right, and if as a regular matter, every 5 or 10 years, that some kind of humanitarian intervention occurs, a unilateral humanitarian intervention, and they don't happen that often, but when they do happen, if we habitually see the ICC prosecutor declining to indict, then it seems to me that may well tip the debate in the direction of saying, okay, we've got a new norm here in the jus ad bellum which allows for humanitarian intervention. The further thing I would say is that if the ICC prosecutor doesn't indict, it may well be the case that he or she says why they're not indicting, right? And we saw this sort of when we saw the questions about should NATO countries anyone in NATO countries be indicted for war crimes in the bombing of Serbia, right? We saw the OTP, the Office of the Prosecutor at the Yugoslav Tribunal, setting up a committee to investigate this, doing a full-blown report on it, communicating that report through. It was made public, and the prosecutor, shows up at the Security Council and sort of explains what's going on. I think you're apt to see at the ICC the prosecutor feeling they have to stand up and say, why am I not indicting these people that engaged in these sorts of interventions? And if that happens, you start to see maybe greater clarity on what are the criteria for an acceptable humanitarian intervention. Now, there may be some where they do indict because they don't think it was truly humanitarian. I think that's fine. It still sets up, what are the lines between permissible and impermissible intervention. Very final note, those who favor humanitarian intervention may think this is great, right? And maybe it is great. I don't know. I'm not taking a position on that. But I would say there's a cautionary note here, right? If the ICC prosecutor becomes the go-to arbiter for what was a good humanitarian intervention and what was a bad intervention because it wasn't humanitarian, that's a very risky position to be in, because you're certainly the center of attention, but you may well be the center of a huge storm as well. And while I've limited this to talking about humanitarian intervention, there's no reason why the same type of analysis wouldn't apply to rescue of nationals or toppling of a democratically elected toppling of a military coup that ousts a democratically elected leader, right? Restoring a democratic leader. There's all sorts of ways that maybe the ICC ends up, in the position of being the final say on this, and that's a very risky thing unless they get it absolutely right, and they'll never get it absolutely right because people are going to disagree about whether the conduct that occurred should have happened. I'll leave it at that.
Next, we have Professor Michael Newton.
And I forthwith yield my time to the distinguished professor from Georgetown. It's good to see you.
That would be George Washington University.
Actually, it is such a joy to be here, of course, because there's so many good friends. But until Shawn said something, we haven't even talked about financial meltdowns all morning. And that's, it's a relief, appropriately, to do that. I say that because I actually got the inspiration for sort of the angle that I wanted to take on this on an airplane about 3 weeks ago, talking to somebody about financial meltdowns. He related this story to me. He's a much older man. He related this story to me. He said, when I was a young man, my first mortgage, he said it was hard. There was lots of paperwork. There was lots of process. There were clear rules. It was definitional. And there were consequences to not doing it all. And then he told me this story of his daughter who, as a recent graduate, had graduated 3 months before and qualified on the internet for a $400,000 mortgage. He said, I wouldn't loan her $25. and he said, and that is what is wrong with our economy. It got me to thinking about the risks of overextension, and it's particularly related to these topics of humanitarian intervention and terrorism, because this is not an academic theoretical debate. I agree with Ben Ferencz completely that anything that works in the real world has to be perceived as building on the Nuremberg legacy, having some effectiveness, not completely devoid. In other words, what we're not about doing is creating, Shawn used the word, a cautionary tale. What we're not about doing is creating this esoteric theoretical body of law that can then be ignored at every time in every situationally dependent, convenient way. So I'm about pragmatism, which is sort of my personality and style anyway. I want to give you 3 points, and then I want to flesh them out. And by the way, I solicit anybody that can help me think of a catchy title for a paper on this line, I'll pay you. I believe that the problem with aggression is not a problem of prescription. In the sense, and that may sound counterintuitive, we know it when we see it. Kuwait, we know that's aggression. We can debate, if you agree on the facts with the Russians, you can say, that's aggression. We know it when we see it. It's not a problem of prescription. It's a problem of it's a failure of power, a failure of process. And to that extent, incorporating a valid, workable, pragmatic structure into the ICC can help remedy that gap between prescription, normative goals, and real effectiveness in the world. And that, I would submit, is the only way, for those who are adherents to a deterrence model, that's the only way you're going to see any effect in the real world and any actual deterrence. But in keeping with my theme, those things operate in the real world. Let me give you 3 principal points, and then I'll flesh them out in a couple of ways. One, any definition of aggression, and conversely, in accompanying with the definition, we talk about the definition, but an accompanying trigger mechanism, remember they go hand in hand, that ignores humanitarian intervention as a reality in the world, the normative element to do that, what Shawn called the trenchant minority, or that ignores the reality of terrorism in this world, is bound to be ineffectual and bound to be ignored and underused and simply cast off as theoreticians operating in a non-functional way. Second point, and I think this is, at least for my purposes as a practitioner, perhaps the most important as a mechanic. Any definition of aggression and trigger that ignores the reality of the existing structure of international criminal law is also bound to be ineffectual and unworkable. And here let me pause before I give you my third and give you a couple of examples. We've talked already this morning about the relationship between command responsibility, the authority of the leaders who order and facilitate, and the broader doctrines of joint criminal enterprise and obedience to superior orders. That's one dimension. I think it's a very important dimension. We can't ignore this dichotomy between a very well-developed doctrine of joint criminal enterprise, which we've seen, of course, in the high command case. Anytime you get a military staff together or a military civilian staff, by definition, you have a joint criminal enterprise for a common criminal purpose, if that purpose is to commit aggression in a neighboring state. The problem is, of course, we can't create a strict liability regime. There has to be some workable, functional, legally defensible distinction between levels of responsibility and levels of accountability in light of the broader field of humanitarian law, criminal law principles. That's point one. Point two, the reality in the ICC statute itself, and this has been one of the gaps that really has surprised me in all of the debates. If you look at Article 30 of the ICC statute, it specifically sort of lays out, and of course was a huge focus of debate in the elements discussions, but it lays out, it says, criminal accountability in this statute attaches when there's intent and knowledge. All right, and so then you go through, and the intellectual question is, all right, now what does that mean in the context of this array of crimes where we now have detailed elements and specificity? And the way we work that out, which is now in practice in the court, is that the actus reus was required to be committed with intent, with specific intent. So you can read the word intentionally in almost an invisible ink before every actus reus in the ICC. All right, so you go through there. Now the question is, and this gets back to the issues that Cherif alluded to this morning, that's a very important, and I would argue, an essential element of proving criminality in the structure of the International Criminal Court. What are you going to do with a whole array of cases that are arguably mixed motive cases, the mixed motive humanitarian intervention cases, or in fact legitimate terrorism cases where in fact a state and a leader of a state says, not only do I have the right to defend myself and my citizens from an act of transnational terrorism, but I have the obligation. And in fact, it is not my discretionary, all right, it is my sworn constitutional obligation to respond to these actors. And I think that's a real problem in terms of the mechanics of proving cases. And then the last fundamental point, and I'll come back to this, is that we can't ignore fundamental purposes. I appreciated Mark laying them out very nicely this morning, Mark back there. Mark laid out security, sovereignty, human rights, and I can't remember your fourth. Stability. Well, listen, remember this. Why is Article 2.4 in the Charter in the first place? I would argue it was to preserve stability. So, take that full circle. In a world in which there is an articulable basis for humanitarian intervention and a huge body of literature and a lot of discussion about that, and in fact in a world where the law of terrorism has developed enormously over the last 15 years, particularly over the last 6 to 7 years, the law of terrorism has developed in an enormous array of ways precisely to balance both those needs, the rights of stability and the rights of sovereignty, the right of sovereign self-defense. So in that world, I think you have to be very clear about what purposes are served by your definition. And in fact, if you commingle, if you create a hodgepodge definition, it actually has the very potential effect of undermining those fundamental values, particularly the overriding value of stability. What you don't want is to create a specific rule that is muddled and crosses purposes in a way that actually undermines stability, and people can say, see, here's the definition, I haven't violated it. Now I have done whatever I've done, but you can't pin me with the express mens rea, the express definition al actus reus. I think it has the potential for undermining stability. So I think we have to be very careful on that. Let me say a couple of words, and then I'll come back to this theme. A couple of words about Article 2.4, which is, of course, replicated in the preamble to the Rome Statute itself, right? We all know the language. I don't take, as a personal view, an absolutist view of that, and I'm far from alone in that, right? There are plenty, both in state practice and legally defensible ways of using force that I would argue are still within the fundamental purposes of the United Nations Charter. Well, there's a lot of state practice here. Rescue of nationals, for example. Deterrent rationales. And in the old days, we talked about reprisals. Would anybody argue that the UN Charter simply outlawed reprisals in its own right at that time? I would say no. We did that later with another body of law. So there's plenty of permissible uses of force outside the UN Charter. This is for those sort of purists, the philosophers go back to Kant. Article 2.4 is actually drawn from the Kant's fifth preliminary article. But Kant himself wrote two express conditions for that, which I think are directly relevant to our modern context in both the humanitarian context to one extent and the terrorism context in another way. Kant himself wrote two express exceptions, and here they are. One is anarchy in a disintegrating state. In other words, the concept that fundamental values of stability, sovereignty, human rights are endangered. Kant himself, even in light of his fifth imperative, would have said that kind of intervention in another sovereign state is permissible. And in doing that, he would have picked up a very specific, I won't read it because of time, but Hugo Grotius wrote exactly the same thing. He wrote, I won't read you the whole quote, but that states not only may, but ought to endeavor, here's the quote, with all their power to deliver the oppressed. So this isn't an era where we're elevating state sovereignty. And then Kant's second exception, and I think this is what we've done with the creation of the ad hoc tribunals and the repeated use of the phrase, which we've all grown so accustomed to, XYZ, as my European friends would say, XYZ is a threat to international threat to peace and security. Therefore, the Security Council exercises its Chapter 7 authority to permit the following type of action. Kant would say that's okay because the right to non-intervention was premised on the existence of all states as, in his words, a federation of free states. Now carry that through. What he really meant by that was states that uphold sovereign democratic values. A state which is oppressing its own citizens, committing genocide, widespread crimes against humanity, even Kant would say, has stepped outside the federation of free states, and therefore other states have the obligation or the right to take action to remedy that. Okay? And I would argue that by drawing on this deep heritage, Article 2.4 actually preserves a fundamental right, because remember the rest of Article 2.4 that's already left out, right? Any other purpose not consistent with the purposes and principles of the UN Charter. The UN Charter is not a values-neutral document. It is a fundamental document that, for its time, took the largest step towards the preservation and enhancement of human rights than any document in world history. So is it any surprise that now we've come full circle and we've said, oh, but there is a humanitarian dimension in there, implicit, built into that. And the other important consideration is that sovereignty, sovereign considerations, were not simply obliterated by the language of Article 2.4, right? Article 51, which we all know and use in our practices, but it talks about the implicit, inherent sovereign right of self-defense, which brings you back to the terrorism arguments. I don't believe, and I don't think anybody in this room that practices would argue that restricting terrorism solely to the criminal law dimension, which is one of the elements in the United Nations strategy, the World Counterterrorism Strategy, is the appropriate or the effective response. I mean, after 9/11, with the clear integration of Al-Qaeda in Afghanistan, would anybody argue that there wasn't a legitimate right of self-defense, in that case linked to state responsibility? I don't think so, not with a straight face. The problem is, of course, for a purist looking at Article 2.4 and elevating the principle of sovereignty, respect for sovereignty, above all the other values, you could make the argument that, well, everything setting aside, irrespective of that, that's unlawful aggression and it should be prosecuted. I don't go down that road because, in fact, there's a combination of values, which brings me to my last example. What we've seen is an evolution in all of these fields, from the nature of raw politics, the nature of raw world order, to and because of that, the untidiness of that, there's a normative push for codification. So law. So you have power, then you have law. And as the ultimate extension of that, of course, inevitably, there's the development of a criminal prosecutorial process. In other words, there's power, then there's law because of the normative impulse. And then, of course, in every one of these contexts, whether it's terrorism, whether it's aggression, whether it's in every other context, then there's the normative push for enforcement. And that is exactly what we saw with the development of the ad hoc tribunals. There was power, there was a response to that, there was the development of law, then there was the creation of normative enforcement mechanisms in the tribunals. And here's the point. When we begin to commingle purposes, sovereignty, human rights, fundamental principles of civilized society, we create the real opportunity for imprecision that I would argue in the end has the real potential for undermining those values. So go back to the Georgia example. Are we going to live in a world where we have principles against transnational aggression, and yet we allow the simple invocation of the fact that, oh, some citizens in that other state are, I call it the mere invocation rule. And we would say no. We have to create a rule that doesn't allow the mere invocation of a humanitarian purpose to then create a blank check for any act of transnational aggression. On the other hand, we have to effectively strike the balance that the proper interest of defense of nationals, defense of national interest, the obligation to defend yourself and your citizens against impending transnational terrorism is respected. Because I would argue that if you do that, you actually have come full circle and you have a failure of prescription. In other words, you have prescription that serves no useful purpose in the real world. And I think that's the challenge that we all want to avoid if, in fact, we want to make any real progress, as Ben would say, on addressing the crime of aggression. And there's much more to be said, but I'm out of time.
Our next panelist is Elise Le Gall-Garnier.
So good morning. So as you can notice, there's a change in the program. Michael Byers was supposed to present this morning, but he was unable to make it today because, as you may know, he's running for Parliament in Canada. So given that we co-authored the paper together, I'm the one who has to present it. So I want to thank Professor Shawn to have accepted this change, and I've accepted the only student, not even in law, to present in this conference. So I'm very pleased and a little nervous actually to present in front of such a distinguished audience today. But I really consider my participation in this conference as a great opportunity to first learn from all the specialists that are gathered here today, and also to improve, thanks to your comments or feedbacks, the draft paper we submitted to Professor Cherif. So considering I'm not a lawyer nor a law student, I'm going to do my best to really present and defend the argument we made with Professor Byers, but please feel free to directly contact him if you want after the conference. So in our paper, we argue that an agreement by the ICC state parties on the definition and condition of jurisdiction of the crime of aggression was much needed, but that these provisions must include an exception for those individuals engaged in an UHI. The international humanitarian intervention. I'm sorry, I'm always using acronyms. So the applicability and the validity of this waiver should be evaluated in relation to the mental elements provided by Article 30 of the Rome Statute. So our argument does not intend to really reopen the debates and discussions on the downfalls and virtue of a right to UHI, but simply to suggest a way in which the provision for the crime of aggression can be made to conform the international situation in which human rights violations are repeatedly committed, but action by the Security Council are too sporadically taken. So while in our paper we addressed the different definition of the crime of aggressions and different condition of jurisdiction, and we also took position on this issue, I will not address this today, due of course to time constraint, but we'll just really focus on the explanation of our argument. So my presentation today will be in 3 parts. First, I will present the downfall of prosecuting the crime of aggression in the absence of an exception for UHI. Second, I will explain how we conceptualize the condition of use of this waiver. And thirdly, I will conclude by presenting what we believe to be the virtues of our clause. So first, what we believe to be the shortcomings of classic prosecution for aggression. So adopting a definition of the crime of aggression that embraces solely the exceptions derived from the UN Charter and GA Resolution 3314 would mean that in the presence of an established actus reus, so in this case of an act of aggression, and of a mens rea confirming the intent and knowledge of the state's leader to commit the said actus reus, the ICC would ipso facto, following a failed exercise of jurisdiction by the state, be invested with the ability to initiate prosecutions against those individuals. This is not per se problematic, since it is, in the broader context, a very common procedure. Additionally, the presence of a definition is required if the body responsible for determining aggression is to have bases upon which to found its claim, and also to inform the international community of its jurisdiction, so as to create a deterrent. A predicament emerges, however, in the present situation where horrendous human rights violations are regularly perpetrated, but inaction by the Security Council is too often witnessed, as was the case in Kosovo in 1999. So in such situation of a stalemated Security Council, or just of lack of political will, in unilateral initiatives such as OAF, although generally considered illegal under the UN Charter and customary international law, may constitute the only options for stopping bloodbaths. Although we're conscious that to pursue a solution in stark opposition with the prevailing system of sovereign equality can hardly be considered as the best method of solving a human rights emergency, one must realize that for now there is just no other alternative. We are conscious that some scholars are developing alternatives to ease the deployment of humanitarian intervention, but unfortunately these still remain at the stage of ideas. So in the absence of a waiver clause for UHI, the likelihood of spontaneous intervention aimed at halting human rights situation will be greatly compromised, given that the leaders and instigators of such intervention would no longer just face international disapproval or condemnation, but could face international criminal prosecution as well. So we know that unilateral humanitarian interventions have been rejected and condemned by over 130 countries through unilateral and joint statements, such as the Declaration of South Summit of Havana or the final documents of the movement of the non-aligned countries in Cartagena. Nevertheless, NATO's intervention in Kosovo was widely tolerated, even by those countries most opposed to the war. While these two positions seem to be inconsistent, they reveal that most countries recognize the need for UHI in specific circumstances, such as in Kosovo with OAF, while remaining opposed to a creation of a general legal right to unilateral humanitarian interventions. So this attitude that we could qualify as resistant is at least partly rooted in a widespread concern that UHI would be used as a pretext for inappropriate interventions without a humanitarian goal. So regardless of whether this concern is founded, it should be assuaged by the development of very strict criteria for the granting of the ICC's UHI waiver, and also a reminder that the presence of an exception within the Rome Statute does not amount to a general legalization of right to UHI. Indeed, the use of this waiver does not protect the state from international condemnation, enforcement action by the UN, diplomatic or economic retributions, or legal action by the ICJ. So to some degree, including an exception for UHI in the Rome Statute will require the drafters, commentators, and state parties to weigh legality issues against legitimacy considerations. So the question the international community must now face is whether it wants to adapt its legal system to accommodate its array of beliefs and norms, such as its faith in fundamental human rights and the dignity and worth of the human person as found in the UN's Charter Preamble, to the point of overcoming the sporadic flaws of the actual system. I will now explain to you how we conceptualize the UHI waiver. So as I previously mentioned, the criteria for having recourse to the UHI waiver clause should be determined by the mental element provided by Article 30 of the Rome Statute. So the exception this overriding clause intends to provide is really one of ultima ratio. So to render immune from prosecution the perpetrators and aiders of an act of aggression genuinely undertaken to end or at least limit the perpetration of massive human rights violation when otherwise international inaction would take place. Given the very exceptional nature of this clause intended to exempt an individual from criminal responsibility, the burden of proof would be on the defendant and not on the prosecution. Although we are conscious that Article 66(2) of the Rome Statute clearly states that the onus is on the prosecutor to prove the guilt of the accused, it should be noted that while this clause intends to uphold the presumption of innocence of a defendant, the proposed waiver aims to expunge the criminal nature of a perpetrated act of aggression. So this arrangement is also in line with the maxim necessitas probandit incumbit quid agit, and I don't want to confuse you, so I will do the translation, which is the necessity of proof lies with EU complaints, since the individual seeking the exception is not the prosecutor, but the defendant who wished to be discharged of criminal liability. So I will now address briefly the two constituents of the mental element, so the intent and knowledge, which require really a distinct examination in order to establish whether an intervention labeled as an act of aggression was in fact led by a sincere and dominant humanitarian motive. So first, Clause 2A, emphasizing the intent of the state or coalition of states to become involved in the intervention, proves to be superfluous in relation to UHI, since claiming protection under this waiver requires recognizing the perpetration of an act of aggression. As a further step, one could require the defendant to acknowledge the illegal character of their action. The recognition of such illegal exceptional illegality as proposed by Byers and Chesterman, would first avoid setting precedent while eliminating or reducing any damage to the international legal order. So the bulk of the work in connection with the intent essentially relate to Clause 2B, in which the leaders of the states or coalition of states responsible for the intervention must demonstrate the humanitarian intent behind their actions. So they will have to prove that their primary goal was to alleviate a humanitarian crisis. So this intent will have to be substantiated with regard to the planning of the operation, the sequence of the action, as well as the objective of the operation. And assessing the intent of an intervention will require actually an in-depth examination of events and actors, since we will need to uncover not only the general intent of the intervention, but also the detailed factual and logical rationalization underpinning this intent. So regarding the knowledge requirement now, to be granted the use of the UHI waiver clause, the existing circumstances of which the intervening state must have knowledge is first, a situation where gross human rights violations are taking place, and second, where the appropriate international actors are unable or unwilling to respond through the normal legal channels. So given the potential of abuse, if any violation of human rights were sufficient to warrant invoking it, a very high threshold for UHI has to be established. So as proposed by Kristen Schinken, for example, this threshold could be the perpetration of action amounting to crimes against humanity or genocide, since these situations most definitely warrant immediate action. However, as outlined previously, the existence of such offenses alone cannot justify unilateral interventions. Its responses to such crises exist within the UN's normal system of collective security. So the waiver clause can only be activated after the UHI instigator has also witnessed the usually responsible body's inaction, whether due to inability or unwillingness. So I will now conclude by presenting what we believe to be really the virtues of having such a waiver clause within the Rome Statute. First, given that it is based on a distinct and deeper interpretation of the Article 30 of the Rome Statute, rather than an entirely new principle, the clause does not impact other provision, nor the essence and purpose of the statute. Second, the formulation recognizes the Security Council's central task and responsibility with regard to halting situations that threaten international peace and security. So the waiver clause does not undermine the existing legal ways of interventionism. Third, the system for determining the applicability of this waiver clause is complex, as it both examines the more subjective element of the intent of the leadership and the more objective knowledge of the concurrent existence of grievous human rights violations and international inactions. So the many cumulative elements required before the immunity clause can be invoked would not constitute an incentive for a generalized rush toward greater unilateralism. And finally, and maybe more broadly, given that adopting the waiver clause requires the prior recognition of a shortcoming within the normal legal system, the waiver actually can encourage greater active study into the development of alternatives to unilateralism. Thank you.
Our final panelist is Professor Larry May.
Thanks. You know, I always have too much to say at these things, and so it's gonna be difficult for me to do this. I typically give talks at philosophy departments or conferences and political science ones where you're given 45 minutes or an hour to speak, and I'm just still not used to this idea of trying to talk for 15 minutes about what I want to say.
Time's up.
Exactly the feeling. Yeah, there it is right there. And part of the problem is that, you know, a lot of folks talk about their paper as if, you know, there are these things there that you can sort of extract and talk about it, when in fact the paper that I would present is itself the thing, and so it's very hard to do. In any event, I want to thank Michael Scharf also for inviting me, and I want to say just a brief word of thanks also to Roger Clark, whose work actually inspired my work on aggression, so what I'm going to do is to talk a bit about some themes that I've developed in the book that you've already heard that I published. And I'll just start by saying that the idea behind the book was that we could learn some lessons about how to address these seemingly new issues, like how do we define aggression, and what do we do about terrorism, and how do we think about humanitarian intervention, if we go back and look at the development of these same topics in the just war tradition. Specifically, for me, the greatest source of inspiration comes from the 16th and 17th century. And so what I'll do is I'll give you a bit of a hint of where that comes from, as really a way just to whet your appetite for reading the book and then the article that I'll prepare for this conference volume. So, okay, I want to start by giving you a quotation from Thomas More. This is from 1516, okay? So this is a very long time ago. This is 500 years ago, okay? And Thomas More is talking about how his preferred people, who he calls utopians, but today it doesn't really quite translate the way that utopian was used earlier in the conference. These are the folks who he thinks are the sort of best people. How would utopians regard the prospect of going to war? He says, quote, "Utopians go to war only for good reasons, and among those are really only three," he says. First, to protect their own land. Second, to drive invading armies from the territories of their friends. Or three, to liberate an oppressed people in the name of humanity from tyranny and servitude. Now, I actually think that this is quite a great place to start. And if we think that these topics are completely new and we have to start from scratch, we're really kidding ourselves. I mean, this is 500 years ago, and I think it's a very nice. Now, I don't actually agree with everything that More says, and there's a debate that then ensues, especially important, I think, between Thomas More and Hugo Grotius, writing 100 years later, about specifically the first of these. That is, whether it is a just war or a war that has a just cause to go to war to protect your own land. And Grotius says, no, that he doesn't think this. That, again, now quoting Grotius from 1625, he says, right reason does not prohibit all use of force, but only that use of force which is in conflict with society, that is, which attempts to take away the rights of others. Now, what I've taken away from this is the idea that for there to be, well, in our terms now, for us to think about and act as aggressive, there has to be not just a violation of the territorial integrity of another state, but there has to be some violation of rights, some violation specifically of human rights to go along with this. This is an idea that I think Grotius had and expounded as a kind of defense mechanism against a long tradition that was epitomized in the position that I just gave you by Thomas More. Grotius thinks that the important question is, were there human rights somehow being violated? And the reason that he thought that was so important was because if you're going to go to war against another state, we have to recognize that rights are going to be violated in war, and there has to be, especially if you're thinking about humanitarian intervention, there has to be some kind of offsetting thing that's going on. So if you go to war in order simply to stop someone from invading an unoccupied part of your territory, there's a mismatch that has occurred. Simply violating the territorial integrity of another state does not trigger a sufficient rationale to think that war can be waged, even as a matter of self-defense. So that's the first point that I want to make, that there is a very long tradition of thinking about these things and of worrying about whether the right concept to use is whether territorial integrity has somehow been compromised. So my proposal is, and one that I argue in the first couple chapters of my book, is that we think about just cause in a slightly different way from the way that Thomas More thought about it. That we think about just cause in terms of preventing or stopping a wrong committed by a state or state-like entity against another state or subsection of a state, which is sufficiently morally serious to be analogous to the risk of large loss of life that war involves. On my proposal, just causes for war concern preventing or stopping wrongs from occurring, not retaliating against states for committing wrong. Just causes for war are not merely violations of territorial integrity, but only ones that involve threats to the lives or basic rights of the members of a state. Just causes for war are not merely violation of a state's sovereignty by another state, unless the state whose sovereignty is violated is protecting the human rights of its members and can no longer do so, or where the sovereignty violation jeopardizes human rights in some other significant way. This is the first part of what I want to say. So then the question is, how does that affect the contemporary debates about how we define aggression? In many of those debates, one of the questions is, who is the state who has engaged in what's called the first strike? And I want to say that that's the wrong way to go. That instead we should replace all of that talk, a la Grotius, by asking the question, which state has engaged in the first wrong? So think for a moment just about the question about whether Russia has engaged in aggression against Georgia. Well, now, as some of you may know, Russia said we didn't engage in aggression, we engaged in humanitarian intervention. Now, how are we to sort this out? How are we to figure out which it was? Well, at least in part, the question is going to be, whether Russia was provoked in somehow into engaging in the action that it did engage in. If so, then the first wrong, the key first act, was by Georgia, not by Russia. And that's the aggressive act rather than the act of Russia in response. And it doesn't make any difference whether territories were crossed or not. Provocation, of course, doesn't necessarily involve crossing territory at all. It could mean just building up armies on a border or something. Okay, so that's the sort of background, I guess, for what I want to say about these two topics that we're to address on this panel. The two topics that we're supposed to address, well, I'm probably already running out of time that I could have used in better ways if I was used to this kind of presentation. The two topics are supposed to be about humanitarian intervention and terrorism. So the final couple of chapters of my book address each of these topics in some detail, and I'll just give you a bit of a hint of what I want to say. So Thomas More listed, as I said, the liberation of an oppressed people in the name of humanity from tyranny and servitude as a just cause for war. And as far back, actually, as the very early Middle Ages, with Augustine, the founder of the just war tradition, Augustine had said that defense of others was a better reason to go to war than defense of self, since the former was more selfless. And there's a sense, I think, in which we've come around to that position, at least some people have today, in a way that I'm not sure is the best strategy. Today, humanitarian intervention is often talked about as a better reason, as somehow a purer reason to go to war than even self-defensive wars. It's become the sort of new paradigm case of where we think it would be justified to engage in war. I think if you read the debates in the 17th century, especially between Gentili and Grotius, you come away realizing that that's a very bad strategy to take. And let me just give you a hint of why that is. Humanitarian intervention almost always involves, well, it's going to involve the loss or the risk of significant loss of life. And more so, I think, than other kinds of armed intervention. If what you're trying to do is to stop a genocide, what's it going to take to stop a genocide? For instance, in Rwanda. So most people seem to think that it would have been a justified basis for war if a state had somehow intervened into Rwanda to try to stop the genocide. Now, what would it have taken to do that? First of all, it's not clear that there were any military targets that could have been attacked. So then what would the armed intervention have to do? Some have suggested that what you would have to do is to somehow secure enough fear in the population that they would somehow put pressure on the government to stop supplying machetes and whatever, or somehow to stop individuals from engaging in acts of genocide. Now, the kind of massive violence that it would take to do this is simply not generally talked about, and would probably, in my view, be much worse than the kind of violence you're trying to prevent. And that's, I think, the major difficulty with humanitarian intervention. And this is something that you can find recognized back in the 17th century as well. There has to be a balance, and we have to think hard about exactly what the consequences would be of authorizing or somehow legitimating the use of force, use of armed force in order to stop something like genocide or an ethnic cleansing campaign. In most situations, I think, it can't be justified. And that seemed to be the position in the 17th century as well, reacting to a 16th century doctrine that Thomas More espoused. Final point that I want to make concerns terrorism. Here's another way we could think about the terrorist stuff. So what's the equivalent of terrorism in the 17th century, 16th and 17th century? It's piracy. And so you think about, well, how do you deal with piracy? Well, one way you can deal with piracy is to simply treat all pirates as enemies of humanity, right? And somehow as outside the realm of humane treatment. That's one way you can go. And that's has parallels today in the way that people think about terrorism. But a more common way in the 17th century was to say, well, there are some pirates and there are other pirates, right? And we can sort of classify groups of pirates in terms of how state-like they are in the way that they act. Similarly, we can talk about terrorist groups like Hamas as being very different from terrorist groups like Al-Qaeda. And one way that you could draw that distinction, similarly to the way that you think about various forms that piracy took in the 17th century, is to think about to what extent you have state-like behavior on the part of terrorist groups. And I think that's a good place to start, again, in that kind of discussion. If I had lots of time, I'd spell it out for you in more detail. Last point that I want to make, and this also comes from Grotius, it really is about jus in bello rather than jus ad bellum, I guess, and that is how to treat terrorists. Now, some people, again, think that the standard rules about how we treat prisoners, generally how we treat combatants, are off the table when we're talking about terrorists, because they don't recognize the rules of the game either. Very similar kinds of arguments were made in the 17th century about pirates. And the response by Grotius was to say, no, the way that we treat people reflects how we are, reflects our humanity, not theirs. And the key is not to somehow degrade your own humanity in the way that you behave toward others. That was the key consideration, Grotius says, that should pervade. And I think that if you take that seriously and you come to recognize what the arguments are and that the arguments are good ones that Grotius has, you realize that treating terrorists as somehow enemies of humanity doesn't necessarily mean that they should not be treated humanely. Thank you.
We will now take your questions. Please.
Thank you. I've got two or three questions. The first one is to Shawn. And taking into account the ICJ's decision on Bosnia versus Serbia, where it talks about due diligence for third states for the prevention of genocide. The way I read the court's decision is that it stops way before saying that states will be entitled to use force to avoid genocide. Of course, that's my reading of the decision. To me, the court it says states should use their due diligence obligation by imposing economic sanctions and so on and so forth. But I don't see the court saying they could go as far as using force. It's my first point. Second point, Elise was mentioning this waiver clause for humanitarian intervention based on Article 30, which I don't think actually works because Article 30 refers to general intent, not to specific intent. If you would like to use a waiver clause, you would need to include specific intent into the crime, saying that would permit to exclude humanitarian intervention. Otherwise, Article 30 is too generic, would not allow for that type of waiver. And finally, I mentioned in my presentation before, and I truly believe that the way to, I understand that you've been trying to justify interventions for humanitarian reasons or for terrorism, which I think are very valid. Now, how to build that into the system, and I still insist, as I said in my presentation, that through the inclusion of a specific intent into the definition of the crime would allow for those instances that are not aimed at a specific objective that will be that specific intent, as Article 6 with the genocide, which says with the intent to destroy in whole and part, blah, blah, blah. If our definition says the use of force with the intent of, I don't know, changing regimes or whatever you want to say, that will allow for those exclusions to happen almost automatically. So you don't need to mention them explicitly. Thank you.
You had music accompanying your question there. It was pretty exciting, actually. Do you want us to go ahead and...
Please.
Okay, so I basically agree with your implication from the Bosnia-Serbia genocide decision. You could even point to, perhaps more convincingly, the Nicaragua decision in 1986, where the court at paragraphs 267 and 268 talk about how using force to protect human rights would not be a justification. Now, in that case, it actually hadn't been advanced by the defending state, since it didn't show up for that phase of the case. But I think if you were trying to, pull out the international court's general view on unilateral humanitarian intervention, the best prediction would be it would say no. Having said that, it's never squarely addressed the case. It's never actually had a case on the merits that was on point with it, and yet it's pretty resistant to uses of force. If you look at just every time these issues come before it, they seem to be pretty conservative and hewing very closely to a classic charter interpretation. But part of the point I was trying to make was that while I think that's right, and while if you were to ask, what generally does the General Assembly think about humanitarian intervention, the answer probably is hostile to it. And other, possible loci of authoritative thinking, but it's in general it's very kind of uneven. There's not sort of a consistent practice that I've seen emerge that seals the door on those who are advancing the legality of unilateral humanitarian intervention. So my thesis is that if the ICC develops the way it might, maybe we end up with a relatively authoritative decision maker there, charged as a matter of law, not just politics, right, of the General Assembly or whatever, but law, to opine on whether this kind of action is permissible or not. And if it does that in a manner that regularly seems to allow it, that's when I think the debate shifts over. But I take the point on the current assessment of what the ICJ might do with it.
Another question, please.
Yes. If you insist upon an ad hoc definition of aggression with many clauses and exceptions, don't you run the risk of being ineffective in stopping any aggression at all, and don't you in fact descend to the very perverted theory of justice put forward by Thrasymachus in Plato's Republic, Book 1, that justice is the right of the stronger to oppress the weaker?
Do the exceptions swallow the rule then?
Well,
Humanitarian intervention.
Go ahead. It's not clear to me that having so many clauses is what's the problem. I mean, I guess I'm not sure I understand the question. I mean, if the stronger could still win out over the weaker, whether there are lots of clauses or few clauses in the way that aggression is defined, it would seem to me Thrasymachus is going to get his way regardless. If he, I mean.
I agree. I mean, that's why. I mean, I really think you have to focus on the core values, and Oscar just said it. I think exactly right. You have to focus on the core values that are being served, and simplicity is the servant of success in this context.
Well, I just, in support of the sentiment of the question, I think, if we end up with an ICC that ends up kind of saying some things are allowed and some things aren't, on the one hand, that's a great thing if you want a more nuanced approach to the jus ad bellum. That is, if you're not really happy with this black and white, it's got to be self-defense and everything else is unlawful. But it does open the door to a sort of slicing and dicing where it becomes a little less clear where the lines are, right? It's just not as obvious. And maybe the ICC gets it right and the lines do become obvious, in which case maybe we've advanced the ball. But I take the sentiment of the question of, it's possible this just confuses everybody. And those that fear, opening the door to humanitarian intervention, the fear isn't that we don't want to protect human rights. The fear is that it's going to be a license for a lot of countries to go off and do things and dress it up like it's a permissible intervention when in fact something else is going on.
Thank you. Please.
Thank you. My question is to Mr. May.
Question of what normative
before
system do you
asking, I just
want?
want to mention that I'm from Georgia, and so far my country is I think the latest victim of aggression. And for those who doubt that, I want to let you know that in August 7th, hundreds of Russian armored vehicles and tanks and thousands of Russian soldiers just overnight crossed internationally recognized border and bombed certain parts of Georgia, territory of my country, all over the country, and they have effectively occupied 2 parts of Georgia as of now, and so they refuse to withdraw. So this is the situation, and I don't think that there should be any doubts cast whether who is victim here. But what is my question? I noted with interest your idea about who has done the first wrong, I mean, including somehow. I think it is a good idea, but at the same time, we should be very cautious with that. For example, Russia invoking at this point that they had to protect their citizens or do something in Georgia, that's why they invaded. So Russia tries to say that Georgia was did first wrong when tried to actually seize control of the territory, but perhaps wrong goes beyond that, and perhaps Russia itself was wrong when for years was sponsoring rebels, when giving out his passports to Georgian citizens or some rebel groups, or delivering munition to Georgian territory, and violating the airspace of Georgia for years. And actually, I must say frankly that my country and my people are the people who just currently and latest weeks is experiencing how ineffective international system is, and how people and nations try to just block out real situation on the ground when they face such kind of nuclear power as Russian Federation just rolling over Georgian territory. I would say rolling over United Nations Charter and the tertiary system. Thank you.
Well, I don't disagree with most of what you said. I mean, in fact, I think I agree with all of it. I mean, what I was trying to say is that there's a kind of yet another cautionary tale about how humanitarian intervention is regarded. I mean, Russia thought that by throwing down that, all of a sudden then the debate would change. That if it could show that there was, in some sense, it was engaged in humanitarian intervention, then it was on the good side, not on the bad side. And that's part of what this panel is about, is trying to say that shouldn't be allowed to work. And what I was saying is that there's a very long 500-year history of seeing just that point. So I don't disagree with that at all. I do agree that what happens with this debate is going to have significance for lives of many people, and that's one of the really interesting points about this, I guess, from the standpoint of an academic conference like this, is that we're not just debating these things in the abstract. They're going to be very significant consequences from it all, but you yourself point to one of the problems, right? Whether we're talking about first strike or first wrong, we're going to be forced to engage often in a kind of historical discussion. Who actually was the one who provoked whom, and who did the first thing that was the act of provocation? That's still within even thinking about it in terms of first strike, and there it's going to be very hard in many cases to sort this stuff out, especially in the middle of Europe, where there are so many things that have gone on for so long that both sides have seen as wrongful.
Thank you, Professor. And ladies and gentlemen, let's give our panelists another round of applause.
So that ends the morning session. There are box lunches right across the hall, drinks in the hall. If you'll bring your box lunch back here at 10 after, which is in 10 minutes, we'll begin the keynote luncheon speech by Ambassador Vanavasi. So I'll see you in 10 minutes.